And welcome back. I'm now joined by Greg Remmenga, and thank you again for coming in. It's another free legal advice segment, and what are we talking about today?
Well, last week we talked about you've just been in an accident, so you need to start getting medical care. Well, we're going to continue with that theme. Right after the accident, you need to be aware of what you're going to have to prove at trial so that you can start planning and protecting yourself. In Colorado, the person that hit you doesn't owe you anything for your wage loss, for your medical bills, technically until a jury says so.
Okay.
The way that we try to get settlements is we convince the insurance company or the person that hit you that they're going to have to pay those funds anyway, so they might as well avoid a trial.
Right.
But it's still the filter we have to look at. So you need to know right away what you're going to have to prove. One of the first things is that the other person caused the accident because they were careless. A lot of times the insurance companies don't really fight this because it's fairly obvious, and they'll stand up and admit, yeah, we ran the stop sign.
Yeah.
The part that they're really going to start to fight is, did the accident cause the injuries?
Okay.
You are going to have to prove what your condition was before the accident, what this accident did to you, and how it's going to affect you the rest of your life. This may seem a little bit strange to some people, but even though you're the victim of the accident, you're the one that's going to be on trial. What was your condition like? What did you do to treat? And the whole time you're doing this treatment, getting ready for the MMI, getting ready to complete your medical treatment, you need to be aware that this is going to be looked at through the eyes of a jury. If you skip treatments, a jury may not like that, so therefore the insurance company is not going to hold favorably. If you exaggerate your treatment, that may not look good to a jury, so the insurance company isn't going to give credence to it. So yes, you're the victim, but you're the one that has to prove all these things. And then the final thing you have to prove is what's the monetary amount necessary to compensate you for all these losses.
Like appropriate for the situation.
Right.
I guess, yeah.
We have the wage loss and the medical bills. Those are fairly easy to calculate as long as you don't exaggerate. Here's what my medical bills were. Here's the days I missed at work. The one that's real difficult is pain and suffering.
Okay.
Pain and suffering is that wishy-washy thing. How much did this injury cause you to lose your ability to have fun and live pain-free?
Okay.
Some people might think that that's worth a lot of money. Other people might think that it's not.
Yeah.
Some people in the valley love to go hiking. Some people don't. So if you're a hiker and you just say, I love to go hiking, the jury might not agree with you that it's worth anything.
Right.
So you have to start preparing in detail what you like to do and why it's important to you. And that's how we try to prove the damages segment, how much this is worth.
Okay, awesome. Well, appreciate all that information. Thank you very much, Greg. And did you want to talk about what's coming up next week?
Well, I had a person call me, and I welcome those calls. They want to talk about some estate planning and survivorship on a deed.
Okay.
Rights of survivorship.
Awesome. Tune in next Wednesday. We'll have all that. Thank you, Greg, again.
Thank you.
We'll be right back.